And Judge, the reason for this offer, if the court is inclined to follow it, just so you know, the motion was actually filed 10 days before she was set to expire out completely. So we're just trying to double back and address the addiction issue.
All right, Ms. Verdine, in cause number 22-40028, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the third-degree felony offense of obstruction or retaliation, and that was a 3-year deferred probation. Is that correct? The motion alleges that you violated your probation. Is that 1 through 5?
It is, Your Honor.
Count 1 alleges that you provided a urine sample June 26th, October 15th, and November 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Yes, ma'am. True.
That's marijuana.
Yes, true.
Okay. Count 2 alleges that you failed to successfully complete the GED program as directed. Is that true or not true?
True.
Count 3 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you tested positive for alcohol June 26th and October 15th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening October 14th of 2025. And is that true or not true?
True.
And then count 5 alleges that you failed to successfully complete the moral recognition therapy program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probation and extend it for 2 years. Order that you enter and successfully complete the JCDI program, which would also include a drug patch. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Verdine is not competent.
No, Your Honor.
So I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I do want to get an updated report. So we need to figure out between now and then what I can do between now and then. I just want to make sure that probation also agrees that that's all of the treatment and everything that's necessary. I'm willing to set a bond, and she's on probation. She can go ahead and start those programs, but I want to make sure, I think, that we're covering everything, if that makes sense.
Judge, she's been incarcerated for a while. Would the court consider a PR bond?
Yeah. So, okay. So what I'm going to do, Ms. Verdine, is I'm going to reset your case for sentencing. I'm not going to sentence you and extend it today. We're going to do that later. But I am going to reduce or set a bond for you in the amount of $1,000, but make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail.
Yes, ma'am.
You're still on this probation. You're required to do everything, including starting that JCDI program. You have to have a drug patch on within 24 hours of your release from custody.
Yes, ma'am.
If you don't do that, I don't have to go along with this agreement when you come back. If you test positive between now and then, you're going to be right back in jail. Do you understand?
Yes, ma'am.
You can talk to your probation officer about where to get that drug patch. They'll help you with that. And then we'll see you back at sentencing. Okay.
Yes, ma'am.
All right. You can go back with the bailiff.
I have a question.
Hang on just a second.
Is the drug patch right now just gonna be a condition of a bond? Or,
It's going to be both.
okay,
It needs to be a condition of probation and bond. Yes, ma'am.
I forgot.
Sorry.
I forgot.
Okay. If you think of it, Mr. Rojas will be around. You can tell one of the bailiffs. All right. You go back to the bailiff. Good morning. Are you
Good
Tan? You're Tan Van Pham?
Yes, ma'am.
And Mr. Pham, you are charged in cause number 25 DCCR 0909 with the state jail felony offense of theft of property from May 3rd of 2025. If you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in state jail prison. Do you understand?
Yes. Depend on my lawyer. If she say yes, I have to say yes, ma'am.
No, I want to make sure you understand. And do you
I-
understand? Do you need an interpreter? Would that be better?
Yeah, that's better because I don't understand English very well.
Well, we've been able to communicate,
You have
you know,
the
fine.
whole time.
Yes, ma'am.
So, Mr. Fan, if you go, I just want to make sure in all of your cases, every single case, you've got 25 DCCR 0909, 25 DCCR 1039, 26 DCCR 0353, 54, 55. And then we've got 25 DCCR 0782 and 0785. All of those cases charge you with theft of property with previous convictions, which means if you're found guilty, the range of punishment, you could go to prison for a minimum of 6 months up to 2 years in each of those cases. Do you understand that?
I know, but I don't do like that, you know.
I just want to make sure you understand that
Right.
if a jury finds you guilty, what the range of punishment is,
I
what could
I,
happen?
I don't know what it means because my English not too well, you know. But I don't do like
We're
that.
gonna reset it 1 week. Let's get, figure out who we can get as an interpreter, please. You speak Vietnamese?
Yeah, I speak with them.
Okay, we'll see you next week. We'll figure it out.
Okay, thank you, ma'am.
Yes.
Thank you so much.
I don't know, yeah. All right, Mr. Larzo, what's going on?
Ma'am, I'm going ahead. I want to question the lawyer. He not representative.
Here's the thing, you don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not, just because
Can I
he's,
speak?
nope, not while I'm talking. I already gave you an opportunity earlier and I'm gonna give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney. And another attorney is not going to come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on,
I want a new lawyer. I don't.
hold on.
I
I understand, but listen.
want to let me speak, man. Please, can I speak? Please?
I'm going to let you speak, but I'm going to give you what your options are, okay?
I just want. All I want is a effect. What I'm saying, you trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He
I'm
already said.
sure
When I said you haven't. He have not one asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not
asking
saying
a
I'm not in
question.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's
one-
the evidence.
the
That's what
evidence.
he's telling you the
I
evidence
understand
is what's in.
that's what the police report said, but he hasn't asked me my side. It's a.
And here's the thing, your side is important if you're going to, if you didn't do it, what his job is to tell you, this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready
Is
to go
there,
to trial.
is there media in this
Judge,
case?
if, as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Do you want, let's do this. Do you have some media?
Judge, I have requested the media. What I told Mr. Larzo yesterday when he told me he wanted to watch the video, I told him we could reset the date to look at
Sure.
the video. He just said he didn't want to do that. He just wanted
Right.
to come in and ask for a new lawyer.
I want to because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he's just said that yesterday he would bring.
This courtroom moment shows just how powerful a judge's discretion can be. After admitting to multiple probation violations, including failed drug tests and failure to complete required programs, the defendant stood at a crossroads. The evidence was clear and the consequences could have been immediate, But instead of sending her to jail, the judge chose to offer one final opportunity. It wasn't mercy without limits. It came with strict conditions, including mandatory treatment and constant monitoring. The message was clear: this is your last chance. In the justice system, decisions like this can define a person's future. Now the question is whether she will take this opportunity seriously or face the consequences she narrowly avoided today.